adding focus on the family and the organizations, the other organizations mentioned in this document, to the LDS Church and the Catholic Church that was discussed in the prior document, is that a coalition you've seen before, arrayed against a particularly minority group in the United States in a political battle?
I would say that there's probably one other issue position against which such a coalition might emerge, and that would be a pro-choice abortion rights position. Apart from that, I can't think of a minority group against whom such a coalition has been raised.
Thank you. I would like you to now turn to Plaintiff's Exhibit 2554, and I'm going to ask you some general questions about this document. I would like you to refrain from mentioning any of the names, but because, as you can see by the approach of Mr. Thompson, there's an objection to admission of this document. But you have seen this document before?
I have.
Does this document shed any light on the powerful political forces arrayed against gay men and lesbians in connection with the Proposition 8 campaign?
Your Honor, if I may object, this is...
Let's get an answer to the question first.
I'm sorry, Your Honor.
Excuse me, yes, it sheds light.
All right, Mr. Puno.
Yes, Your Honor, this is still under attorney's eyes only confidentiality. As the court can probably see from the body of the message, the to and the CC designations from all appearances, this is an internal communication among leadership of a particular church. I don't see anything that connects it to the Prop 8 campaign or that it was disclosed beyond the church leadership officials that are listed there. So we would object to testimony about this document.
Mr. Boutrous?
Thank you, Your Honor. First, without revealing anything other than the following, I think I can reveal that it references the fact that the effort being discussed in this email is in concert with the leaders of many other faiths and community groups forming part of the ProtectMarriage.com coalition. This is a document that we received in production from the proponents of Proposition 8 in this case, in the wake of the order rejecting their First Amendment claims and defining the core group. So I think it's not subject to a First Amendment privilege. It was clearly disseminated more widely than those who saw it, and therefore I believe it should be admissible.
Your Honor.
This Mr. Bentley is not one of the individuals that had been designated or that have been designated as the core group. Is that correct?
That's correct, Your Honor.
Your Honor, I really must clarify this document. How do you say this? Whether or not any of these individuals are in the core of ProtectMarriage.com is a completely different issue. This is a document in the possession of one of our clients who is, or at the time was, a church official and had a document in his possession revealing communications with other church officials. And that's the body of this. Now, it may relate to Prop 8, but there is, I think, that it would be very troublesome to say that religious organizations, churches lose their ability to communicate within their leadership in the church because the church works with other churches and other organizations, even in a cooperative way in a campaign.
But as I understand it, this is a document that was in ProtectMarriage.com's file.
No, Your Honor. In the file of an individual who is an official proponent.
One of the parties?
One of the intervener individuals, not the campaign committee.
But it was in that individual's file.
That's right.
That individual is not part of this religious organization, correct?
He is, Your Honor. That individual is a member of the organization, a member of the religious denomination, and at the time had a position of authority in that church, and was sent this email in connection with his, in other words, Your Honor, someone can be on the executive committee and be an official proponent and they can also be involved in their church. And this is a communication about Prop 8 among church officials with one of our proponents who was also a church official. In other words...
Well, he's one of the proponents. He's an individual intervener defendant in this case. The document relates to the Prop 8 campaign. If there has been a disclosure...
It relates to the church's support of Prop 8. This is not a publication of a campaign. This is not a document produced by ProtectMarriage.com. This is an internal church communication.
I don't understand. If it is a document that relates to the Prop 8 campaign, in the files and possession of one of the defendant interveners, how it can have some kind of privilege attached to it?
Well, there's
It obviously falls outside the First Amendment privilege as defined by the Ninth Circuit.
Absolutely agree with that, Your Honor, but because that First Amendment privilege articulated by the Ninth Circuit was with regard to the campaign's internal formulation of messaging strategy. We are on a completely different field here. We're dealing with the religious association of a religious denomination and their ability to communicate with one another within the walls of the church.
Mr. Boutros.
Your Honor, I would make a couple of points. First, I don't see how Mr. Puno and ProtectMarriage.com have standing to assert this First Amendment privilege on behalf of the people who wrote this document.
Well, he can't
No.
assert it on behalf of the individual he represents.
Right, the individually named defendant.
Mr. Jansen.
Which named defendant are we talking about?
Mr. Jansen.
Mr.
Jansen.
Jansen.
Yes.
Okay.
So assuming there is some level of standing, I would direct the court to the first sentence. And again, I think I can read this without bringing down the First Amendment.
I'm going to object, Your Honor, to this internal church communication being read aloud in court.
Well, let me try it this way, Your Honor. The document on its face says it relates to the role in public affairs of the Prop 8 campaign. And then in the third or the fourth paragraph, it talks about the campaign and the fact that certain officials, who I won't name, even though I don't think that name is confidential, who report directly to the ProtectMarriage.com coalition leaders. So it seems to me this is a classic. It's a document that's in the files of a person who sat on an executive committee of ProtectMarriage.com precisely to play this role in this broad coalition that breaches and breaks down any limits between these groups for this effort in the political sphere, and then arrays against the folks on the other side of Proposition 8. So I think it's hardly the kind of sensitive religious tract that might otherwise be subject to protection under the First Amendment.
Your Honor. Your Honor, Mr. Jansen testified in his deposition that he, at the time, was a member of, forgive me, I don't remember the exact name, but it was the Public Affairs something office of the Church of Jesus Christ of Latter-day Saints. That was a role that he played independent of the executive committee of ProtectMarriage.com. The references in capital letters in title caps to public affairs are a reference to those church officials. And there's also a mention in the CC to I won't say it out loud, but another leadership in the church. So this is an internal communication of the church. It certainly refers to the larger Prop 8 effort, but unless there is a communication from Mark Jansen to another organization in his capacity as an official proponent or as an executive committee member, which this is not, then we really are not having to be even concerned with what the core is and so on. So this is an individually asserted First Amendment protected right of Mr. Jansen to have in his possession an internal church memo that he does not have to produce in court.
The content of the document appears to relate to the messaging of the campaign. Mr. Jansen is a party to the litigation. The issue of his role in the campaign is very much an issue in this case, and he intervened to serve as a party in the case. And I think it appropriate that the plaintiffs have sought from and obtained discovery concerning his role. And apparently his role relates to his religious affiliation. And I'm not aware of any privilege that attaches to that under these circumstances. And the objection will be overruled.
Thank you, Your Honor. With that, I would like, I would like to publish the original version as redacted. Not any other version, but the original version to the screen. Thank you. Professor Segura, I'd like you to look at the very first paragraph of this document and enlarge that on the screen so we can take a look at it. If you could read that into the record and then give me your views on the significance, if any, of that statement to your opinions.
Since the first presidency letter was read in every ward throughout California last month, I have been frequently asked what our role in public affairs will be in Prop 8 campaign.
And in the third paragraph that begins, as you know, if you could read that, and then maybe you can talk about the significance more generally with response to the entire document, rather than going through it one by one, paragraph by paragraph.
Sure. As you know from the first presidency letter, this campaign is entirely under priesthood direction, in concert with leaders of many other faiths and community groups forming part of the ProtectMarriage.com coalition. I believe, name redacted, will be the LDS chair for all of California, with the help in Southern California from...
Well, why don't you just skip
that
for now.
I will. All of us working in public affairs will simply stand by and prepare to be anxiously engaged, like all citizens and lay members, when that time comes.
And then if we jump down to the next, the paragraph that begins, what is the necessary step of this campaign? Could you read that into the record, and then tell me your views about this document?
What is the next step in this campaign? I understand that all grassroots organizing efforts in OC will be led by, I believe his name is not protected.
I believe that's correct.
Gary Lawrence, who will report directly to the ProtectMarriage.com coalition leaders.
Your Honor, somewhat after the fact, I need to object that Mr. Lawrence's role in another capacity was not protected and was disclosed and has been open, and public in this whole trial. His capacity here has been, as far as I know, protected, not disclosed.
Well, recall the Ninth Circuit that
It would have been nice to have a chance to redact this, but maybe.
Well, the Ninth Circuit protected communications, internal communications involving the core group. Now, this would appear to be a communication that mentions Mr. Lawrence, but it's outside of a communication among the core group. So the mere fact that an individual is in the core group does not mean that his or her name cannot come out in some other way through the course of discovery.
I don't disagree with that at all, Your Honor. Just that individuals have privacy rights to be able to be involved in a campaign and to not have their name become part of the public record against their will in connection with things that they did not do in a public way.
Mr. Lawrence has been afforded core group protection for his internal communications. This is not one of those communications.
He was a polling and researcher for the campaign, polling and so on. Actually, The protection was Lawrence Research, the company, and Judge Sparrow order of January 8 says that the protection is given to Lawrence Research, the company, through which the campaign did polling. This is attempting to reveal without an opportunity to redact a completely different role that he had that was not a public role.
Mr. Boutros?
Your Honor, Mr. Lawrence's name was public. He was publicly associated with the campaign. And this paragraph talks about the fact that the efforts in OC, which I guess is Orange County, will be led by Gary Lawrence, who will report directly to ProtectMarriage.com coalition leaders. So it's talking about his role in a campaign, a public campaign to pass a law in California. And the fact that religious organizations participate in the political debate is a perfectly fine thing. But once they do, and they're public, and there's no support for the notion that we suddenly keep people's names secret even though they're associated publicly. And from a First Amendment perspective, probably one of the most basic principles is that once something is public, courts and other governmental bodies aren't allowed to keep it secret without a compelling reason. So Mr. Lawrence's name is public. He has been well known to be associated with the campaign. I can't see a First Amendment interest in not noting that he was playing a principal role and liaison role here with this broad-based group of coalition leaders.
Last word, Mr. Puno.
Your Honor, I realize the nuance that this company did research and polling. He had a completely different hat that he wore at this company that was not a public hat. And if we're going to start revealing those, I don't see a distinction between this and production of a list of every volunteer who helped in the campaign.
Well, this individual appears not to fit in the category of the famous Mrs. McIntyre was the subject of a good deal of litigation in the Supreme Court. It is important to bear in mind that this is a public campaign. It is a political campaign. It was out in the open, and the people who advocate on either side as a result of their advocacy, and particularly their participation in the litigation that follows, inevitably subject themselves to disclosures of the kind that are contained in this document. And I don't see, frankly, Mr. Puno, that there's a privilege or a protection that applies to this document or that applies to Mr. Lawrence's role in this communication. An internal communication with other members of the core group is a different matter entirely. Very well, proceed, Mr. Boutros.
Thank you, Your Honor. Professor Segura, if you could finish reading that paragraph, and then we can move on to your opinions regarding this document as it relates to political power.
Okay. He has also been hired by the coalition to do the polling work for Prop 8. The main California grassroots leaders are in the process of being called as, quote, area directors, end quote, with the responsibility for areas that generally correspond to each of the 17 LDS coordinating councils for the LDS mission boundaries. Thereafter, priesthood leaders will call local prop coordinators over each stake and leaders by zip code within each ward, potentially working not only with LDS but LDS volunteers.
In your opinion, Professor Segura, what does this document relate to in analyzing the degree of political power of gay and lesbians, and particularly with respect to the Prop 8 campaign?
Well, there are at least two things worthy of note. The first is that there is a very close coordination between people involved in the church and the campaign from an organizational standpoint. Phrases like, this entire campaign is entirely under priesthood direction are notable. The other thing that I take notice of is the term called. So it is customary in the practice of the LDS Church for volunteers to be solicited through encouragement. So it appears that there was an LDS volunteer in every zip code to coordinate those activities, which is, once again, a very enviable political organization. I think any political candidate would be pleased to have such a thing.
Thank you. Your Honor, I wanted to make sure that with all the back and forth, the plaintiff's exhibit 2554 had been admitted into evidence.
It has.
Thank you, Your Honor. Professor Segura, let's move on to the plaintiff's exhibit 2555. Is this a document that you have reviewed over the past week in connection with your work on this case and your analysis of the issues in the case?
Yeah, it is.
Your Honor, I apologize, but I must lodge another objection, and perhaps I could just... I apologize, but I must lodge another objection, and perhaps I could just lodge what will be a standing objection. These are minutes of a church meeting. I can't imagine how this is not protected from disclosure in a federal court trial, especially, Your Honor, this has got to be protected information.
Well, I think we need a foundation for this document.
I will establish one, Your Honor. Thank you.
All right.
Professor Segura, did you reviewed this document, and did it shed any light on your analysis of political power?
Is this witness able to lay a foundation for the document?
This witness can testify that this was a document we represented to him, was produced by proponents in this case pursuant to the production order, and that he reviewed it, and that it's relevant to his opinion.
And your representation is from what source did this document come?
This document was produced by the defendant interveners in response to our request for production, after they began to comply with Judge Spiro's order rejecting the First Amendment claim. So I think it falls into the same category as last document 2554.
It does appear to be the minutes of a stake meeting. I gather, Mr. Puno, this is a document that came from the files of protectmarriage.com of one of the individual intervener defendants.
I can say, Your Honor, it was one or the other. I'm not certain which, but I suspect
Well,
it
if
was...
in fact it is what it appears to be, the minutes of a stake meeting, but it was nonetheless in the files of an organization other than a religious organization, I can't see how it would enjoy any religious institution privilege, if there is one.
Well, Your Honor, just to clarify, I'm almost certain this came from Mr. Jansen's file. As far as the named defendant interveners, he's the only one that I'm aware of that is a member of the LDS Church. These are the minutes of a meeting of church members and officials, and the fact that it was in Mr. Jansen's possession, I cannot imagine abrogates the privilege to be able to communicate with. There really is no First Amendment protection here, Your Honor, if having a copy of your correspondence with other members of your church in your possession abrogates your First Amendment rights.
Well, it's a rather lengthy attorney-client privilege. Confidentiality must be maintained, and it appears that this was not done in connection with this document. Mr. Jansen may have had multiple roles, but his role here is in the role of the campaign. This document apparently relates to that activity.
Your Honor, there is no evidence here that this was sent to anyone by Mr. Jansen. This is in Mr. Jansen's shoebox under his bed. This is the minutes of a meeting that I haven't looked to see whether he was in attendance at the meeting. But this, I know that he was a public affairs official at the time of the campaign. But my point is, is that Mr. Jansen did not send this to anybody. The only reason this is here is because a federal court told him to take it out of his shoebox and bring it to court.
Shoebox.
It illustrates the point. Sorry, Your Honor. Did not send this. He did not send this to his neighbors. These are his private records of his private political religious associations. How in the world can that be compelled to be brought into court and laid bare into public record?
But this appears to relate to the Prop 8 campaign.
It clearly relates to this religious denomination's public affairs meeting, part of which included a discussion of a ballot measure and the efforts of the members, in which anyone on either side of the issue has a fundamental right to associate with others, including in their religious organizations.
Regarding questioning the fundamental right of association is not being questioned. No one's questioning the right of Mr. Jansen to participate in a political campaign. But that does not afford a right against the disclosure of his role, what he did.
Well, Your Honor, then I would suggest that unless there is something in this document for which a foundation can be laid, that he had anything to do with the matters discussed in here, then I have to object on a lack of foundation.
I think I can lay that foundation, Your Honor.
I beg your pardon. I beg your pardon, what?
Yeah, I think I can lay that foundation.
All right.
On page 10685, which would be the second page, and this is really the paragraph that begins legislative update.
Yeah. Yes.
That's really the remaining portions of this document. I think we could probably redact even more if it goes into the record. But this is the key part, the part that says Mark Jansen reported on the California Constitutional Amendment Proposition 8. And then it goes on to describe the public activities with protectmarriage.com, this broad-based coalition. That's really what I would like to direct the witness's attention to.
Very well. The objection will be overruled. 2555 is admitted.
Thank you, Your Honor. Please publish Plaintiff's Exhibit 2555. So focus on, if we can go right to page 1685, the paragraph that is entitled Legislative Update. And actually, if you can put the paragraph that follows that as well. And while that's happening, Professor Segura, give me your impression as to what this document, this portion of the document relating to legislative update is doing in terms of this memorandum.
As I read it, Mr. Jansen is reiterating the strategy that's to be employed with how church leaders and church members should present themselves with respect to Prop 8, to the Prop 8 campaign.
And in what? What is it about this document that leads you to that conclusion?
Particularly, the first two sentences of the second paragraph, quote, Brother Johansson emphasized that we are not to take the lead on this proposition, but to join in coalition with protectmarriage.com. Salt Lake City conducted a teleconference with 159 of 161 stake presidents in the state of California and told the presidents LDS are involved in this issue but are not to take the lead. Teach youth and young adults the doctrine of marriage by using the, I assume that's a letter read in sacrament meetings. And LDS are encouraged to contribute the fundraising $30 suggested donation. Brother Johansson announced that $5 million is the projected goal in addition to general fundraising. Donations are best provided to protectmarriage.com.
Then if we could turn to the next page, excuse me, 10686, which is the stamped number on the bottom of the page. The paragraph begins, we are asked. I would like you to focus on the first and the last sentence of that paragraph, and then tell me your views on the connection between this document and political power.
We were asked to wait patiently for talking points from the coalition.
And then how about the last sentence?
Director Holland highlighted the luxury of having Mark Jansen on key committees and that he will receive direct communications, I assume, from him.
As a political scientist, what is it about this document that these statements that is relevant to analyzing the balance of political power between gay men and lesbians and religious organizations to the extent they're involved in political activities in California?
Well, with respect to the Proposition 8 campaign, it makes it clear that there was a sort of two-way flow of information where strategic talking points were being provided to religious leaders by the campaign. And in turn, the religious leaders were providing volunteers to the campaign. But there was this cautious, strategic, not to take the lead notion so as to provide a, plausible deniability of respectable distance between the church organization per se and the actual campaign.
And does that have an impact on how the power of gay and lesbians is viewed by public officials and in the public, that kind of approach to political advocacy?
Well, certainly, because as we're looking at the political opportunity structure, sort of how fertile the ground is for political action and how strong your opponents might be, we might look at the religious belief as a source of opposition to homosexuality and say some number of religious adherents went out and voted their beliefs on Election Day. And I think that's in fact kind of the end of it. But in fact, this appears to suggest fairly close the coordination between hierarchy and officials within the church organizations, as in some of the past documents have illustrated, and the leaders of the ballot initiative.
Have you ever, in your studies, in your review of the literature, and your analysis of political activity in the United States, ever seen this kind of structure constructed and deployed in an effort to eliminate a fundamental state constitutional right of a community group?
This is new in my experience.
Let's jump ahead to Plaintiff's Exhibit 2557.
Okay.
Your Honor, I need to lodge an objection to the use of this document. Again, it is under attorney's eyes only confidential privilege. This is a post-election document, and it refers to activities and financial activities post-election. And so the relevance is a problem, and to the extent that this reveals confidential inner workings of relationships between organization that supported Prop 8, this is highly, highly revealing and confidential, and we object.
Well, not to make light of that, usually why people want to introduce documents is because they are revealing. But it does appear that this is a communication amongst individuals who are part of the core group. Is that not correct, Mr. Boutros?
Yes, it's a communication from someone outside the core group to people who are in the core group.
I see.
Yes.
I see.
The from
The
line.
from line.
And Your Honor, the foundation, there is no question this is an authentic document. It was sent to the, the entire, basically the entire executive committee. Mr. Legge and Mr. Puno himself, Mr. Jansen, Mr. Schubert, who was the political consultant, Jeff Flint, another political consultant, and they are all copied on it. And the reason that it's relevant, without disclosing the full contents, is that it really shows the degree of connection between ProtectMarriage.com and the organization that sent this document in terms of the funding. And the ProtectMarriage.com, in this court, before Your Honor, and in the depositions and in other contexts, have taken the position that these other organizations were not really that connected to ProtectMarriage.com and the official campaign. This document goes directly to that. And as relevant to Professor Segura's testimony, demonstrates this significant, broad coalition that was connected by not only the same views about Proposition 8, but by an incredible fundraising mechanism and relationships. So I think it's directly relevant. It was produced by proponents of Proposition 8. It includes people outside the core group. So I think it should be admitted.
Your Honor, maybe we can confirm the sender. If I could see an unredacted copy of this.
I can show you that right now, Your Honor. I could.
Sure.
Your Honor,
Your Honor, the sender is a person identified in Judge Sparrow's order of January 8 as a member of the core group. Otherwise, we'll just state our continuing objection.
You say that he was identified as part of the core group, the sender.
Well, he was under seal, and he was identified by Judge Sparrow by a reference to paragraph and line number as a member of the core group, not by his name does not appear in the order. It refers to
you've
a sealed
lost me.
declaration. There are 6 members of the...
Did Spiro include this individual as a member of the core group?
Yes, Your Honor.
that one, Your Honor, I don't, there is, I think, one, maybe a core group member or two that I don't even know about, but I would suggest.
Is this John Doe?
No, it is not, Your Honor. Well, this morning's John Doe.
John Doe 1, John Doe 2?
I believe, Your Honor, there were as many as 6 individuals.
How many?
As many as 6 individuals that were identified to Judge Sparrow by John Doe 1, John Doe 2, or something in that nature under a sealed declaration. And the order, which lists the members of the core group, includes those 6 individuals, and that is the individual who sent this communication.
Well, my inclination is to do this. I'm not sure that I follow the John Doe business, but accepting counsel's representation that the sender is a member of the core group, this document is a post-election document. This document is being offered to establish connection between the religious organization and the campaign, that being a subject that I think, Mr. Boutros, you have pursued and have introduced sufficient evidence on. So I will sustain an objection based on the cumulative grounds.
Thank you, Your Honor.
Thank you, Your Honor. And I have just a couple more documents here, Your Honor, that I think the next document, Plaintiff's Exhibit 2561, this is the one to which there is no objection, I am pleased to announce. Professor Segura, is this a document that you have reviewed?
It is.
And did you consider it in forming your opinions, the opinions that you're giving here today?
I did.
Your Honor, I move admission of Plaintiff's Exhibit 2561.
No objection, Your Honor.
Very well, music to my ears, Mr. Thompson.
Well, that was refreshing. If we could publish Plaintiff's 561, please. Professor Segura, briefly, what is it about this document that reflects on political power, in your view?
Going to the heart of the matter, the last sentence of the first paragraph reads, quote, you may know that the Mormons have been out walking neighborhoods the past 2 Saturdays with about 20,000 total volunteers.
And why is that important in evaluating the political power in this context?
Again, I would suggest that any political consultant would be thrilled to have 20,000 precinct walkers on any given Saturday. So I think it speaks to the breadth and size of the opposition to gay and lesbian interests.
Please turn to Plaintiff's Exhibit 2562. Is Plaintiff's Exhibit 2562 a document you reviewed over the last week in connection with your testimony?
It is.
Your Honor, I move admission of this document, Plaintiff's Exhibit 2562. It's another document that was produced by the proponents over the last week.
No objection beyond our standing objections, Your Honor.
Thank you, Mr. Thompson. Very well.
Please publish this exhibit. And I would like to direct the witness, just to expedite things, to the second page. Actually, let me ask. Go to the first page. What is this document, Professor, in your understanding, if you could describe it?
It appears to be an email from the chair of protectivemarriage.com to others dealing with some issue regarding how designated gifts take place to the campaign.
Then let's go to the next page. And is there anything on this page that caught your eye as you evaluated the issue of political power?
There are three things. The first would be everything under the numeral 1.
What is it about that portion of the document that's relevant to what you're talking about today?
Numeral 1 recounts the early organizational efforts, largely among evangelicals, to get church leadership involved in the campaign, and reports that in these very, very large teleconferences, when the message that the campaign wanted to send through the pulpit was discussed. There were 1,700 participants in June and 3,000 participants in July of 2008. And the third bullet point suggests that their goal was to have as many as 5,000 California pastors participate in one of these calls.
Thank you. And finally, Plaintiff's Exhibit 2598. Please turn to that exhibit. And Your Honor, in conversations with Mr. Puno, there are a couple of names in this that I'm happy to redact that we missed. I will refrain from publishing them. But other than that, I don't believe there's an objection to this document and would move its admission. It's another one, a document produced by the proponents.
Subject to the redaction, no objection, Your Honor.
Very well. 2598 is admitted.
Thank you, Your Honor. Professor Segura, since there's this redaction issue, I'm not going to put this up on the screen. What is this document, and what is it about it that sheds light, in your view, on the political power issue?
It appears to be a fundraising letter, and it's to someone who has given generously to the Family Research Council in the past. And the reason I found it interesting was it suggests a coordination of potential donor bases, a sort of sharing of people with capacity, as endowment folks like to say, who are potentially able to give.
In that regard, could you turn to the very last page, which is stamped 009699?
Uh-huh.
At the top of the page, the sentence that begins, "We have the..."
Yes?
Could you read that, and then give me your impression on that in terms of political power?
We have the political and financial support of groups such as Focus on the Family, Family Research Council, American Family Association, the Arlington Group, and many others.
And are those significant groups in terms of political power in the United States when banded together?
Separately and together. Each of them are a fairly powerful interest group representing the evangelical movement in national politics.
Based on the factors that you've described today, as well as the manifestations that you've described earlier this morning, relating to political powerlessness, what is your opinion regarding the political powerlessness of gay men and lesbians in the United States and in California?
Well, my opinion is that when we take together the moments of legislative victory, the moments of legislative defeat, the presence of ballot initiatives, the absence of statutory or constitutional protection, the presence of statutory or constitutional disadvantage and a host of circumstances, including small numbers, public hostility, hostility of elected officials, and a clearly integrated, nationally prominent organized opposition, I conclude that gays and lesbians lack the sufficient power necessary to protect themselves in the political system.
Now, I have two principal lines of questioning for you as we finish things off here. The first is, I would like you to explain whether you conducted any comparisons with the political power of gay men and lesbians with other groups in society, including women, African Americans.
I did.
What were your conclusions regarding a comparison in terms of the relative political power between gay men and lesbians on the one hand and women in the 1970s, for example?
I'll begin with the conclusion. I concluded that relative to the position of women in the early 70s, gay men and lesbians are more disadvantaged today than women were in the 1970s. For starters, women constituted then and constitute today a majority of the population. And were they so motivated, they could determine most, if not all, political outcomes. Second, while there were certainly sexism, and I wouldn't want to, understate the importance of that historically, being a woman is not inherently controversial. Families don't hate their daughters. In fact, women are quite beloved by many people. Third, there were women in public office, some of whom are men, some of whom are women. They were women in public office. There were women in public office. But perhaps most importantly, there was already a statutory protection. The 1963 Equal Pay Act, certain provisions of the 1964 Civil Rights Act clearly protected women at the federal level. So in addition to having more political power, more votes, less or no hostility, there's also the matter that they enjoyed statutory protection.
What were your conclusions regarding the relative political power between gay men and lesbians on the one hand and African Americans on the other hand, before the Civil Rights Act of 1964?
Well, this is a comparison which is a little bit more complex to explain. So I want to try to separate out the political circumstances on the one hand from the social and economic circumstances on the other. Let me begin by saying that being an African American prior to the reenactment of civil rights legislation was a very difficult thing to do in this country. And the quality of life and the day-to-day experiences of African Americans, particularly in the South, is something that we should take quite seriously as historically quite damaging. That notwithstanding, I would turn my focus to the political circumstances, which is what I was asked to evaluate. At the time, that suspect classification was extended to cover racial and ethnic minorities. There were 3 amendments to the United States Constitution that formally established civil equality for racial and ethnic minorities. Admittedly, they were not enforced. Admittedly, there were all sorts of statutory nonsense that took place in the wake of those amendments. But the establishment at the constitutional level of equality was complete. There were any number of statutes that had taken place to protect the interests of African Americans. All of the New Deal legislation, for example, was explicitly race neutral and made a point of making it clear that African Americans were entitled to the activities of the New Deal. Immediately prior to the Second World War, President Roosevelt issued Executive Order 8803, which prohibited the government contracting, the War Department especially, with any business that was engaged in discriminatory practices against African Americans. And of course, the government is the largest single purchaser of all products in this society. So that had a fairly substantial ripple effect in the manufacturing sector. And in 1948, President Truman desegregated the United States military. So again, I think it would be fair to say that socioeconomic conditions were very bad for African Americans in the middle part of the 20th century. But there were a number of instances of statutory protection and even constitutionally established equality that African Americans enjoyed. And at that point, it was the civil rights movement was an effort to bring the social reality in countenance with the constitutional embellishment. By contrast, gays and lesbians are in a different position. So they're subject to a statutory disadvantage. Some would suggest that gays and lesbians aren't as oppressed as African Americans were, and there might be a good reason to suggest, and that's true for at least some gays and lesbians in more open social environments. But the hour is moving in the opposite direction. So in 1990, there was a single constitutional embellishment of inequality for gays and lesbians, and today there are in about 3/5 of the states, there is constitutionally established inequality. So as a constitutional matter, gays and lesbians are moving in the opposite direction than African Americans were in the 1940s.
Well, how about group size? In terms of African Americans and gay men and lesbians, in terms of populating jurisdictions?
Okay, so African Americans in the 1940s were approximately 10 or 11% of the national population. Today, that number is closer to 13%. That varies quite widely by jurisdiction. There are a number of southern states where the black population is well north of 30%. In some cases, around 40%, certainly many cities in which African Americans are a majority of the population. But by contrast, there is no jurisdiction with which I'm familiar. I mean, there might be, a small resort town here and there, but there's no jurisdiction of any size with which I am familiar that has a gay majority.
Well, bringing us forward to today, how do the manifestations of political powerlessness of African Americans compare to the manifestations of political powerlessness of gay men and lesbians?
So, a little bit more broadly about the subject matter of race and ethnicity. There are now 69 persons of color serving in the House of Representatives. There have been as many as 4 senators. That's not the case right now. Some people left to join the administration. And so obviously that compares favorably to the 6 gay and lesbians who have ever served, and the 3 who currently serve in the House of Representatives. Minorities are elected to public office in many parts of the United States. The 1965 Voting Rights Act, and particularly the judicial implementation of Section 2, as it was amended in 1982, have provided numerous opportunities for persons of color to elect members of their community to the public office. And in fact, have been interpreted as affirmative responsibility, particularly under Section 5, covered jurisdictions, that they have to provide opportunities for racial and ethnic minorities to vote for first choice candidates.
How about the presidency?
Oh, yeah, there's that. Well, we do have our first Hawaiian president, but obviously the election of an African American to the presidency is a big deal. I would also go as far as to say, however, and I want to provide the impression that I don't think African Americans in the category of race and ethnicity as instill of significant concern in our society. And indeed, a significant portion of my scholarship addresses that. Just that in terms of political power today compared to gays and lesbians, they are doing quite well.
Finally, I would like to display demonstrative number 8 and ask Professor Segura whether you have any opinions regarding the deposition and report and opinions expressed by proponents, proffered expert on political power, Dr. Miller.
So I do.
Your Honor, we would object that the witness is not put in any report that addresses Professor Miller's analysis. We haven't had an opportunity to depose him on it.
Well, I assume, Mr. Boutros, you had the witness read Mr. Miller's deposition?
Yeah, he attended it, Your Honor.
He attended it.
Yes.
Objection overruled.
Professor Segura, if you could give us kind of the broad outline of your critique of Dr. Miller's opinions and approach.
Sure. Professor Miller approached the question of political power of gays and lesbians somewhat quite differently than I did. And in his deposition, a number of things became clear about both his analytical structure and the breadth of the information that he considered. The first point is that Professor Miller, frankly, doesn't know anything about gay and lesbian politics. During the course of his deposition, he could not identify many of the critical historical figures in the early part of the movement, was not familiar with political science work, including very prominent political science work that had focused on gays and lesbians. He was aware of some judicial scholarship on gays and lesbians because that is his field of endeavor, but even there wasn't familiar with some of the key pieces on how political science would address gays and lesbians. It was also curious that he was unfamiliar at all with the political science work on prejudice, of which there is an enormous amount and of which was well known.
And about his, sorry,
Go ahead.
how about his knowledge concerning the presence or absence of legal protections relating to gay men and lesbians?
I think it's fair to say that Professor Miller did not look beyond the boundaries of California. He focused exclusively on California statute. And when he was asked about other states, he had almost no answer for anything. And in fact, even proceeded to suggest that he would be shocked if it were the case that a majority of the states had no legal protection for gays and lesbians, which of course is the case. When asked how many of the top 10 states don't have any protection, he didn't know the answer. With respect to the protections that have been passed in California, he actually didn't really know the legislative history of most of those as well. So it was really quite striking how little information he had on this. To put it in the starkest terms, in 29 states, there is no anti-discrimination protection for gays and lesbians. And Professor Miller concluded that gays and lesbians possess political power without being aware of that fact.
Do you agree with Professor Miller's definition of political power as he applied it in researching his opinion?
There were a couple of problems with Miller's definition of power. First, that there was a definition was actually quite vague, and he was asked about it in deposition. He arrived at a definition that said in his that said that a group had political power if they received a fair hearing from lawmakers. But there was no investigation in his report as to whether or not gays and lesbians, in fact, have received a fair hearing from the lawmakers. And, of course, this is an initiative process. So who are the lawmakers? The lawmakers are the proponents of the ballot initiatives and the voters. So in the absence of any investigation, I don't understand how, even under his definition, he could conclude that the threshold for political power had been met. But in the case of statutory enactments, where he wanted to say, well, these pieces of legislation constituted evidence of political power, some of those pieces of legislation were actually pursuant to court cases that decisions that had already been handed down. And the attorney deposing him actually asked him, so are favorable court decisions an element of political power? And he said yes. Well, judicial intervention on behalf of insular minorities cannot be considered an element of political power in a fair sense. If the measures of political power is what we're using to decide whether or not judicial intervention is appropriate.
Finally, Professor Segura, how did Dr. Miller's testimony and report square with his own writings regarding ballot initiatives?
Professor Miller's scholarship focuses on how the judiciary has reacted to ballot initiatives. So he spent a fair amount of time researching those. In his actual published research, he has suggested first that ballot initiatives are very likely to result in bad law because they are not as deliberative as legislative process, and that ballot initiatives frequently target minorities. And on both of those things, I'm highly inclined to agree with him.
No further questions, Your Honor.
Very well. Mr. Thompson, you may cross-examine.